Okay, well, sige, attorney, yung ating topic for tonight, no, yung ating pinag-uusapan, truth or myth, no, civil, ano ba to? Civil courts procedure
Court
rule.
procedure. Actually, tama ka. Galing ni Mr. Laragan. Civil na. Civil procedure rules.
Court procedure
Court procedure rules.
Ayan.
At ganun pa rin ang mechanism natin. Kuha na ng scratch paper, resibo, notes, sa cellphone nyo man yan, or any piece of paper. Simple lang. I will say 10 statements. I will state 10 statements. At huhulaan nyo lang po kung truth or myth ang sasabihin ko. And the topic for tonight is civil court procedure rules. So without further ado, let's start with statement number 1. The White Book is another term for the book for civil procedure rules. So, the White Book daw, puting libro, sa ating puting libro, is another term for the book for civil procedure rules. Totoo ba yan? O haka-haka lang? Yan. Number 2, it is optional to follow the practice direction for pre-action conduct. So, optional lang daw tong sinasabi nila na practice direction for pre-action bago mag-umpisa ng isang kaso, merong practice direction na tinatawag. Ito yung kumbaga sinulat ng civil procedure rules. Optional lang daw ba to? Totoo ba o haka-haka lang? Number 3, under the civil procedure rules, you may be penalized for cause if you have breached its provision. So, under daw ba sa civil procedure rules, pwede kang ma-penalty ng cost kung hindi ka sumunod sa nakalagay doon. Totoo ba o haka-haka lang? If you're just joining us, the same mechanism po. Kuha na ng papel, kuha na ng ballpen, huhulaan nyo na naman kung truth or myth ang sasabihin nating statement. The particular topic for today, as you have probably heard me repeat a number of times, it is civil procedure rules or civil or court procedure rules. Number 4, the case management powers of the judges are expressly enumerated in the civil procedure rules. Totoo ba o hindi? The case management powers, yung kapangyarihan daw ng mga husgado to make decisions regarding cases, ay nakalista yan sa civil procedure rules. Totoo ba o hindi? Later on, pag binigay ko na yung answers, I will also expound kung ano yung bakit totoo, bakit hindi, at anong hindi totoo, ano yung katotohanan. So number 5, you are not allowed to apply for disclosure before the case has started. So bago daw mag-umpisa ang court action, bawal kang mag-apply sa korte for disclosure. Totoo ba o hindi? Number 6, cases below £5,000 are called small claims. Cases below £5,000 are called small claims. Number 7, you may get your legal costs back if you win a case with a value of above £10,000, but it will be subject to court assessment. But it may be subject to court assessment. So, pwede mo daw makuha yung legal cost mo back, ma-reimburse yung legal cost mo back if you win the case at ang value no na above £10,000, pero depende pa rin daw, could be, depende sa pag-assess ng korte. Totoo ba o hindi? Number 8, you are required by court in case proceedings to disclose all documents, including electronic documents. So, required daw, mandato daw ng korte na ibigay mo, i-disclose mo lahat ng dokumento na nasa sayo, including lahat ng dokumento sa electronic, lahat ng dokumento sa mga electronic devices mo, which means lahat ng dokumento sa laptop, sa cellphone, and other electronic devices related to the case. So, truth or myth. Number 9, if you cannot make it to the hearing, you can simply not attend and the judge will not make a judgment against you. So pag may schedule clash ka, pwede kang mag-excuse lang, wag umattend at hindi naman magbibigay ng judgment against you ang korte. Totoo ba or hindi? And finally, unless order, yun ang term, means your case will be dismissed or struck out if you do not follow a particular order. Totoo ba o hindi? So if you're just joining us, pareho pa rin po ang ating mechanics. Ito po ang inyong quiz master every Tuesday. This is truth or myth. You will be guessing kung totoo ba or haka-haka yung statement na sinasabi ko, and it relates to today's topic, which is civil court procedures. Number 1, uulitin ko po uli para sa mga late o bagong dating lang. Number 1, the white book is another term for the book for civil procedures, truth or myth. Number 2, it is optional to follow the practice direction for pre-action conduct. Number 3, under the civil procedure rules, you may be penalized for cause if you have breached its provisions. Number 4, the case management powers of the judges are expressly enumerated in the civil procedure rules. Number 5, you are not allowed to apply to the court for disclosure if the case has not started yet. Number 6, cases below 5,000 pounds are called small claims. Number 7, you may get your legal costs back if you win a case above 10,000 pounds, but it will be subject to court assessment. Number 8, you are required by court in all case proceedings to disclose all documents related to the case, including those in your electronic devices, laptop, cellphone, tablet, totoo ba o hindi? And number 9, if you cannot make it to the hearing, like a schedule clash, you simply do not attend and the judge will not make a judgment against you. And number 10, unless order means your case will be dismissed or struck out if you do not follow a particular order. So, ready na ba? Ready na. Exchange papers. Time to check your answers and talk a little bit about the statement. So number 1, balik tayo. The white book is another term for the book for civil procedures. Meron akong props today, so I will get that. I will answer by show and tell. Tcharan! It is actually the white book. So you can see that, it's the white book. Although it's 2018, that is the civil procedure rules that we use. Tinanong ako ni Mr. Laragan kung uso pa ba itong mga madadaming libro sa law firms. And what I said is actually hindi na. Kasi nga, electronic na tayo lahat ngayon and most that we have are database. So, what we have, although medyo classic kami o OG sa tinatawag nila, we still have a civil procedure book. And it is indeed called the white book. So that is true. So if you're a law student, if you hear the term white book, that is that. It's very heavy. And it's very useful. And I will tell more kasi nasa ibang number yung ibang statement mami-mention later on. So number 1 is true. Number 2, it is optional to follow the practice direction for pre-action conduct. Truth or myth? So, bukbak konti tayo ng story. Dito sa civil procedure rules na to, meron po tayong tinatawag na mga rules. So, we say Civil Procedure Rules number 1 or paragraph 1, section 1. Well, we call it CPR 1. So, may mga numbers po yan. You don't really need to go into the details of that. And meron din po practice direction. So, if you're a law student, this is probably very, very interesting for you, especially if you're interested to go into civil litigation. So, yan ang aming, kumbaga, guidance. So how we conduct ourselves in civil litigation. And part of that is what we call a practice direction for pre-action conduct. And as the title suggests, bago po kami magkasuhan, bago pa namin kasuhan yung kabilang partido, kasuhan yung neighbor nyo, kasuhan yung may utang sa inyo, we have to look at that practice direction for pre-action conduct. And it is not optional. It is a requirement by the court for us to pass by that practice direction. And isa doon ang magsusulat ng letter before action with particular direction or guidance kung ano yung contents ng letter before action na yun. So, the answer to that is it's a myth. Dahil yung mga practice direction na yan, yung mga rules na yan, is order ng is a mandate by the court unless it specifically says there. So meron kaming tinatawag na must or may. So minsan we must do it, may is optional. This is practice direction for pre-action conduct is not optional. Number 3, under the civil procedure rules, you may be penalized for cause if you have breached its provisions. That is true. So, ano yung penalty na yan, attorney? Para ba yung parking ticket? Bibigyan ako ng parking ticket ng korte. No, what would happen is, yung kabilang partido mo, yung kalaban mo, yung opposition mo, ang maglilista ng mga kasalanan mo sa civil procedure rules. So, when the court, kung ending na ng kaso, tali na, audit na, sino nanalo, sino hindi, and the court will make a judgment, main judgment, plus ang judgment of cost, you may be penalized. Pwedeng mag-claim ng cost back sa'yo ang kalaban mo, kalabang partido, if meron kang substantial non-compliance ng civil procedure rules. Ang lesson po dyan, mag-follow po tayo. I mean, your lawyers would know, take legal advice. Yun sinasabi namin, take independent legal advice. Kasi may mga pasikot-sikot, may mga technicality itong one lang po yan. Hindi ko pa dinala yung pangalawang libro niyan. May mga pasikot-sikot po ang civil procedure rules. At pag hindi nyo po yan na-follow at hindi natin alam yung technicality, is that you could fall foul of the cost repercussion. So, yun po ang ating moral lesson. So, number 3 is true. Number 4, the case management powers of the judges are expressly enumerated in the CPR. I don't know kung nakita nyo kanina. So, yon. That is it. Indeed, that is true. Yung isa pala, case management powers. Ayan. So, yes, that is true. So, hindi lang po yan, kumbaga, hindi lang yan ad-lib ng mga judges at that particular time. So, they always refer to that. If your lawyer would want them to do something for a case, they would refer to, am I able to do it under my case management powers under the civil procedure rules? So again, if you're a law student, if you want the court to do something, then you would have to refer to that particular area, which is that is part 3, civil procedure rules, part 3. I should know which part it is, but chinek lang natin. So, Civil Procedure Rules Part 3, and dun po ang case management power. So, hindi po yan ad hoc na inisip lang ng may discretion sila obviously, pero kung ano yung kaya nilang gawin at ano yung parameters ng pwedeng magawa ng isang judge are in the case management powers at dun po sa puting libro na yon. So, that is true. Number 5, you are not allowed to apply for disclosure before the case has started. Totoo ba o hindi? That is false. Isa sa mga, kumbaga, technicality na alam ng mga abogado, kahit hindi pa tayo nagkakasuhan, nasa pre-action pa lang tayo, I can actually make a formal request for what I call pre-action disclosure. So kung sa tingin ko itong dokumento na to, kumbaga alam ko kontrata nasa sayo, hindi mo binigay sa akin. Alam ko itong dokumento na to ay importante sa kaso at hihingin ng korte later on. Kung hindi mo ibibigay sa akin yan, pwede akong mag-apply to the court specifically for pre-action disclosure. So that's under CPR 31.16. I think I'm pretty sure because that's one of my favorite. As a lawyer, isa po yan kung may mga tactic tayo na sinasabi, may mga ammunition tayo. That's one of my favorites as a civil litigation lawyer. I would ask and press for, if appropriate lang naman, para malaman natin kung ano ang strength ng evidence, kung ano talaga ang mga ebidensya dito sa kaso na yun. So we call it pre-action disclosure. So tatanungin ka, baka tanungin mo, bakit mo hinihingi ngayon? Hindi pa naman tayo nagkakaso. Actually, no. We can ask for that. We can ask for disclosure even before hindi pa na officially nag-issue ng court proceedings. Okay? So that is 5 is myth or false. Number 6, cases below 5,000 pounds are called small claims. That is myth. 10,000 po ang cut-off for small claims. And I hope nakuha natin yan kasi inuulit-ulit natin yan. So small claims are 10,000 and below. Number 7, you may get your legal costs back if you win a case above 10,000 pounds, but it will be subject to court assessment. That is true. So backwards muna tayo dun sa small claims 10,000 below, you will not get your legal cost back kahit manalo ka. So yun ang nag-change ng dynamics ng small claims. Very, very rare circumstances. May mga exemptions always, of course. But ang default is kahit manalo ka, hindi iuutos ng korte na bayaran ng kalaban mo ang legal cost mo. Pero pag ang value ng claim mo ay above 10,000 pounds, the court may order and will order the other side to pay your legal costs subject to assessment. What does that mean in subject to assessment? So, pwede nyo munang pag-usapan, you can agree it. However, kung hindi kayo agree, syempre, meron na namang another layer of deliberation ng cost assessment. So, hindi po yan automatic 100%. Yun ang moral story of this point. Yes, mananalo ka above 10,000 pounds, makukuha mo from the other side. Magiging liable sila, yun ang technical term. Sila ang responsable sa cost mo, pero pwede yang ma-assess pa rin ng korte. So, yung 100% recovery ng binayad mo sa abogado, hindi po very rare po yun. So, minsan, meron ka pa rin, kumbaga, hindi 80% lang, 75% lang ang marirecover mo. Okay? Number 8. You are required by court in case proceedings to disclose all documents related to the case, including documents contained in electronic devices or electronic documents. That is true. That is what we call standard disclosure. So at some point during the proceedings and quite early on, kailangan mong mag-submit ng disclosure report or standard disclosure report. Na-check mo na yung laptop mo, na-check mo na yung cellphone mo, na-check mo na yung tablet mo, at mabibigay mo yung listahan ng lahat ng dokumento related to the case na nasa possession mo. So you need to tell the court and tell the other side. Hindi po ito yung tatago mo hanggang sa huling sandali. The duty of disclosure is very, very serious. So you need to do that. The reason for that is para kung kaya namang palang baka masettle o it can be solved as early as possible, then magawa na as early as possible. So disclosure hopefully will assist in that. So pati hindi lang yung titingnan mo yung cabinet file mo, but you have to look at electronic devices too. Number 9. If you cannot make it to the hearing, you do not need to attend and the judge will not make a judgment against you. That is a myth. Hindi po na dahil halimbawa sinabi mo, ano kung may clash, may holiday ako, pupunta ako ng Spain. Hindi na lang ako mag-attend. Sisend ko lang sa judge yung papers, and that's all. That is not the right procedure, kumbaga, according to the civil procedure rule. So it happens sometimes. May mga opportunity during the case to give what we call, again, dates to avoid. So pwede mo sabihin sa korte, ay, may big holiday ako dito, ay may exams ako sa ganito. So you can tell the court in advance, and they will try as much as possible to accommodate it, obviously. Pero hindi, minsan, either hindi nakita, or may emergency ka talaga, may emergency kang kailangan puntahan. You cannot just not turn up. Hindi po yun, hindi naman din po yun tama. What you need to do is to make an application of adjournment. So, kailangan meron kang application na formal, may ebidensya, may statement mo, ay ganito, kailangan kong pumunta ng Pilipinas dahil may emergency, I really can't deal with the case, I can't turn up. Even if I send a lawyer, I wouldn't be able to deal with the case dahil meron kaming crisis of family. You put your evidence in, and then hopefully, well, you try to agree with the other side. Baka naman may compassion yung other side at sasabihin, oh, sige, adjourn na lang natin para makatipid tayo ng court time, makatipid ng gastos. Sometimes, siguro, either magdi-disagree yung opponent mo, o sasabihin nila, no, it's up to you to ask the court. So, you still have to make the application. So, you have to make the application for adjournment. And 244, again, may technical form na kailangan gamitin. So, you'll have to use that. You'll have to pay the court fee. Sometimes, there might even be what we call an interim hearing. So, hindi final hearing, i-hear lang sa America tawag, motion ata sa American tawag. So, dito we have an interim hearing. They will hear particularly your case and whether adjourned yung hearing. Sometimes it happens kasi halimbawa ang hearing next month, hindi talaga kasi graduation or sasabihin mo, pwede bang i-move natin at another time. So, there's still time to hear it now. What I would suggest practically is if in your if you are in civil litigation, I really do hope you seek legal advice. Kasi po, maraming aspect na pwede kayong ma-trip up ng technicalities. If you are being represented by lawyers, do tell them kung may change yung schedule nyo, kung may pupuntahan po kayo within, especially kung naghihintay po kayo ng hearing date. Please tell them kung may holiday kayo na planned. Please tell them kung biglang kailangan yung lumipad ng bansa, or do tell them that you'll be away on certain days. Kasi sometimes, baka due na pala yung witness statement mo, tapos 3 weeks ka pala wala. So that's happened, for me personally, that's probably happened to me, wala yung kliyente ko. So we have to adjust yung preparation namin. So work with your lawyers para mas smooth sailing ang pag-run po ng kaso nyo. At hindi natin, ma-avoid natin itong mga extra hearings at extra costs na kailangan. Although, life is not perfect, minsan kailangan talaga, andoon, nasa civil procedure rules. Kung kailangan nating i-move ang kaso, kung kailangan nating may additional na gawin sa kaso, it is there. So do check it. If you're a lawyer to be, if you're studying to be a lawyer, very, very important to know your way around that white book. And finally, number 10, unless order means your case will be dismissed or struck out if you do not follow a particular order. That is true. And we say unless order kasi yun talaga yung nakalagay doon sa korte, sa court order. So the court order will say, unless you pay the court hearing fee by 30th of September, your case will be struck out. What does that mean? Pag hindi ka nagbayad ng hearing fee, tapos ang kaso mo. Wala ka, hindi ka, talo ka na. So may mga ganon. Civil proceedings is very well known to be strict about deadline. So, hindi pwede na, extension tayo o kasi kahit extension, pag hindi ginrun, din yan. So, pag na-miss mo yung mga deadline, there could be fatal consequences to the case. The case could end, you could lose, at pwedeng ikaw ang magbayad ng cost ng kabila. So, ang lesson po dyan, ang ating takeaway dyan, alamin mo din, kung halimbawa sinabi na, well, can I have this document? Can I have this witness statement? Hindi lang po nangungulit yung abogado nyo para mangulit. They really, we have to manage the case accordingly. We have to beat the deadline. We have to make the deadline dahil mabibigat ang repercussions kung hindi natin ma-follow yung directions ng court. So the next time, I don't know if you're the next time na siguro, I hope not. I hope hindi po kayo maging parte ng litigation. But in any case, siguro kung nagre-research lang kayo, nakita nyo unless order, makikita niya. It wouldn't really say unless order. It just will begin with the word unless. Unless you do this, you will be struck out. So it's a huge, huge warning. So that is true. So let's go through it again. Number 1, true. Number 2, myth. Number 3, true. 4, true. 5, myth. 6, myth. 7, true. 8, true. 9, myth. And 10, true. Mr. Laragan, kamusta po?